for the case of Eron Kiza that will be handled yet again today. Good morning to you, Stephen.
Yes, good morning to you. We are coming to you from Trade Towers here in Nakasero. We are the Civil Division of the High Court. Today, we expect a ruling from the judge, Douglas Ngiza, or anyone from the High Court regarding the habeas corpus application that was done from the lawyers of Dr. Kiza Besigye, but also we know that Eron Kiza is one of the lawyers of Dr. Kiza Besigye. He was sent to Chitara prison for a maximum of 9 months. That is after the military court found him in contempt of court. These are lawyers, part of the lawyers of Eron Kiza and Kiza Besigye. I have here George Musi, I also have Katoto Musime and Tobias and others. But let me engage one of them, at least on the issues concerning this ruling, but also the one of the NRM members of Parliament who sat at a table with the President Museveni and said that, you know what, we need to amend the UPDF Act and maybe see again civilians in court martial. Let me begin with Katoto Musime here. First of all, we expect the ruling, right?
Mm-hmm. Yes, we expect the ruling today, but it is so fishy that the prisons are ready and willing. Actually, they communicated that they are bringing Eron Kiza today in court for his ruling, but surprisingly, the judge is saying he did not issue any production warrant. The lawyers are not aware of what transpired. We actually got the information from Chitari and from Eron himself that he will be brought to court today. But to our shock is that the judge is actually not sure whether Eron is coming, and is also asking us the same question. So it's a fishy action that we don't believe he's being genuine to himself, and he's actually telling us the truth. And however much, whichever way it goes, we shall have the ruling the way it is. In fact, we are not interested on which side the decision will take on, because we have seen the decisions he has made. He's just a quarrelsome judge these days. I don't know whether it has now become a habit of judges to quarrel in their rulings and not tackle the issues of and substantiate the matters as raised by the lawyers, but they are interested in their own decision and maybe quarreling with the social media influencers and activists, which is their role. They have to express themselves and give it out. If you are not interested in being criticized by the activists, then do the right thing, follow the law, and also be on point.
You know, today makes it 50 days since he was sentenced. And of course, from the Supreme Court ruling, his continued incarceration, does it really make it his human rights being trampled upon?
Obviously, he's in an illegal detention, as we have already said, because he's being held in Chitaria without a remand warrant. The challenge that these people would face in their individual capacities is that they will be charged and taken on for the violation of individual rights under the Human Rights Enforcement Act. And each person shall pay from his own pockets, including the government being vicariously liable. But we always call upon people, if you have the power and if you hold an office, do what the office requires you to do, because the laws are clear on what you are supposed to do. Pronounce yourself that the detention is illegal and the person should be released unconditionally. That's what we all require from the judge, nothing else beyond that.
That is counsel Katoto Musime from Gisha and Kiza Kampala Advocates, where Eron Kiza is also a partner and he works with him. But also, let me turn to a person who has stood before the General Court Martial defending the human rights of others, but also him being a lawyer, George Musi from I'm forgetting the law firm. Best Advocates, yes. You being part of the lawyers who have sat before the General Court Martial. When we see the Supreme Court ruling saying that, you know what, trial of civilians in court martials should be stopped, and we see members of Parliament sitting with the Commander-in-Chief saying that, you know what, we need to amend the law, amend UPDF Act. What does this spell for civilians like Eron Kiza?
Of course, it spells bad faith. The Supreme Court decision indeed gave some advice and proposals for amendment. However, it seems the main point for the NRM caucus is the issue of trial of civilians, which, if you look at the total of the decision and even the lower court decision, what the court was against that, was against what it asked them to amend, was targeting the independence of the court, the composition of the court, and their competence, such that people, even soldiers, can get some bit of a fair hearing. However, they seem to be treating those on the periphery, and they are streamlining the issue of civilian trials, which I think, if the law is passed in that nature, it risks being thrown out by the Constitutional Court again, because the Constitution bars legislating to defeat a court judgment.
And for Dr. Kiza Besigye, his ruling for habeas corpus, according to court, was overtaken by events. And for Eron Kiza, you were here. I know you are not here by accident. With or without the ruling, what does it mean for the rights of Eron Kiza, who was sent by the General Court Martial on a ruling that later on was defined by the Supreme Court ruling that, you know what, this isn't lawful? What does it mean for his own rights, but also on rights of others who are still on remand and others who are still detained by the court martial, like Machete and others?
Of course, the nullification of the trial meant that the Supreme Court only stopped short of nullifying the proceedings and declaring them a nullity. What that would mean is that we are now seeking subsequent orders for the case of Eron to see that those people are released. And even the Machete has referred an application. So the question would be how responsive the courts are in ensuring that these matters, these cases, are quickly handled and disposed of. Mindful that there are people who are in custody, it's about people's lives, and the transfer of files and the subsequent charging is not within our control, and we don't know when that will happen. So it's important that courts prioritize the issue of rights over anything else.
And finally, for you, Councillor George Musi, is the one of the UPDF amendment, amending the Act. What does it also mean? What should be the members of Parliament know before they go in? Because they could be them, those who are before the General Court Martial, but tomorrow could be anyone else. Is it? Does it also say that members of Parliament don't know that the civil courts have the powers to try civilians and they have to go to the military courts?
Of course, the members of Parliament are prioritizing politics because they are doing what their chairman is asking them to do. In return, I'm sure, for something that they may want to get from him, especially. That has been the practice. That has been the practice because the issue is they have not even the NRM caucus has not fully utilized the reasons or what the rationale for the civilian trials. They have just gone through what the president has been saying all over and over again. So I think, just like we've always noticed, that sometimes history comes back to bite some of these people.
George Musi, Party Nat Pace Advocate, thank you so much. One word from you from Tobias.
Yeah, I'm so happy that we are here to get this ruling. We hope for the best, although he has told us he's not sure of it, but he had promised us that we are going to have the ruling this Tuesday. So, and today is the last day. He told us the last day is 25th. So we hope he obeys by his word, and we hope for success for our brother.
Lawyer Tobias and lawyer Katoto Musime. It's a host of lawyers here. There are so many here waiting for the ruling for habeas corpus for the production of Eron Kiza, a lawyer who is now detained at Chitalia. He was sentenced on the 7th of January for contempt of court by the General Court Martial led by Brigadier General Gabe Freeman. But what is happening here is that they've been told that he